subscribe, hit the like button. If you have legal topics you want covered, please comment and ask, and I will try to do some. Obviously, this is not legal advice, and that's why this channel is called what it is. Today I'm going to talk about the most recent litigation involving Tesla and Elon. It was litigation brought in San Francisco. It was brought by Glenn Littleton, as he was the class member in Ray Tesla securities litigation. It was a claim for securities fraud under the 1934 Securities Act for a violation of Section 10B, and related to tweets that were made in August of 2018 regarding Elon, referencing that funding as to going private had been secured and was imminent. The plaintiffs sought approximately $12 billion in damages and could have sought punitive damages if their damage claim was sustained. It was situated in San Francisco federal court, as federal courts have exclusive jurisdiction over securities fraud. There probably was concern by Elon's attorneys whether he could get a fair shake in California because all the negative sentiment that arose out of Twitter, etc., and probably there was great concern that the jury would be biased. So what happened was the plaintiffs claimed to have relied upon the tweets and bought shares of stock in anticipation of the company going private and their shares going up in value. Unfortunately, after the tweets were made, the deal fell through, the value of the stock decreased, and those plaintiffs lost money, and that's how they justified their $12 billion claim. During the trial, the court did find that the tweets were not accurate, but because the claim was for securities fraud, there had to be a showing of intent, that Elon acted with intent, that he knew they were false, and or that the tweets themselves were material to the investors making their decision. So Elon testified for approximately 3 days. He testified about his contacts with the Saudis and the Public Investment Fund, the PIF, and that they were going to fund it. And he said if they weren't going to fund it, he was going to sell a portion of SpaceX and raise the money. It was estimated it would take $20 to $70 billion to take Tesla private at that point in time. So even though the judge had ruled that the tweets were inaccurate, there was still additional proof that the plaintiffs had to show to prevail in the case. However, I'm sure that once the judge found that the tweets were not accurate, that Elon's lawyer felt that he had a problem and that he was going to need to escape this potential issue. Elon's attorney in this matter, his name is Alex Spiro. He's from Quinn Emanuel, which is a large New York firm, a very well-respected firm. Spiro is a Harvard Law graduate, like my youngest, and he was a former Manhattan prosecutor. He now does basically white-collar defense and related for Quinn Emanuel. So in this particular case, the jury only deliberated less than 2 hours and waited for lunch, and then yielded a unanimous 9-0 verdict in favor of Elon and Tesla. Since the case was in federal court, civil juries have to have a unanimous verdict. In state court, for example, in California, civil cases generally have 12 jurors. In this particular case, there were only 9. But in a civil case in California, it doesn't have to be unanimity as there is in a federal civil case. So the jury waited till after lunch, as I indicated, and oftentimes jurors wait to deliver a verdict till after lunch so they can have their last meal. And I would deem the way the jury came to the result, in that they found Elon and the board not liable. They must have found, especially considering the judge had already found that the tweets were inaccurate, they really must not have liked the plaintiff, Mr. Littleton. They must have not think he really relied upon it, and they must have really believed that Elon believed that there was a deal in in the pending or could be made, even if there was no deal. But the jury must have been sympathetic to Elon, which is interesting because, again, it's a California jury, and they would be somewhat, apparently, somewhat opposed to Elon's interest in the current time. But obviously, the jury must have found that the plaintiff's story was full of poop, and they didn't find that Elon's remarks were reckless. So, as a result, Elon and Tesla prevail. The plaintiffs could file an appeal, but it's unlikely because the class action counsel probably has spent enough money prosecuting this case and doesn't want to spend any additional money, and often appeals are unsuccessful. So I hope that brings this case into a little context, and if anybody has any questions, feel free to ask. Be well.